Hi guys, welcome back to my channel. Detroit is on the map again. Four people have been charged with the death of a 5-year-old. Let's check it out. Go ahead and don't forget to share this video, subscribe if you have not already done so, and I am definitely want to hear your comments on this story.
In connection to the tragic death of a 5-year-old patient inside a hyperbaric chamber at the Oxford Center in Troy on January 31st. Let me first say at the outset, criminal charges are merely allegations and all defendants are presumed innocent unless and until proven guilty in a court of law. Due to many failures by men and women who would call themselves medical professionals and wanton or willful disregard for the likelihood that their actions would cause the death of a patient, 5-year-old Thomas Cooper was killed when a fire erupted inside the pressurized, pure oxygen environment inside the chamber. A single spark, it appears, ignited into a fully involved fire that claimed Thomas's life within seconds. Fires inside a hyperbaric chamber are considered a terminal event. Every such fire is almost certainly fatal, and this is why many procedures and essential safety practices have been developed to keep a fire from ever occurring. The investigation into this tragedy has revealed how the Oxford Center in Troy and several of its key decision makers held safety among their lowest considerations in their hyperbaric treatment practice. Yesterday, 4 people were arrested in connection with the tragic killing of Thomas Cooper. My office has filed charges against the first 3 defendants with second-degree murder. Those charged are the owner of the Oxford Center, Tamala Peterson, her primary management assistant at the facility, Gary Markin, and the Oxford Center's safety manager, Jeffrey Mosteller. Each of those have been charged with alternative counts of involuntary manslaughter, meaning that a jury will be able to decide which charge properly befits their conduct. My office is confident that second-degree murder charges are appropriate for these individuals. This offense requires that the prosecution prove the defendant or defendants acted either with intent to kill or commit great harm, or, as specifically articulated in the law, to have acted in wanton and willful disregard of the likelihood that the natural tendency of said act would result in death. The jury instruction states it even more simply. To prove this charge, a prosecutor must prove that the defendant caused the death, that the death was not justified or excused, and that the defendant knowingly created a very high risk of death or great bodily harm, knowing that death or harm would be the likely result of their actions. We intend to demonstrate in court a series of actions undertaken by these defendants that satisfy these charges and tragically led to this child's death. Should a jury decide the state failed to meet this standard, they will have at their disposal the alternative charge of manslaughter. And to convict on this charge, the jury need only determine that the prosecution proved the defendant's actions caused the death of Thomas Cooper, that the death was not justified, and that in performing the acts that caused Thomas Cooper's death, the defendant acted in a grossly negligent manner. Additionally, we've also charged Alita Moffett, the operator of the hyperbaric chamber at the time the device incinerated young Thomas Cooper, who faces 1 count of involuntary manslaughter and 1 count of intentionally placing false information on a medical record as a medical provider. In the immediate aftermath of the explosion at the Oxford Center in Troy, Troy Fire, Police, and Emergency Medical Services deployed to the scene of the explosion, and the Troy Police Department began an investigation into what occurred. My office was quickly in touch with the Troy Police to offer assistance. We made available to them our special investigative agents and whatever other resources they requested. And through this investigation, remained at all times under the leadership of Troy Police, and they've completed their criminal investigation and submitted their report and findings to our office, where our state prosecutors conducted a review for any and all potential criminal charges. In the course of this investigation, experts on hyperbaric chamber and treatments were consulted extensively, and some horrifying and simple conclusions were reached. Obviously, there will be much we cannot yet fully discuss or disclose until such items are entered into discovery or as evidence, but suffice it to say for now that the Oxford Center routinely operated sensitive and lethally dangerous hyperbaric chambers beyond their expected service lifetime and in complete disregard of vital safety measures and practices considered essential by medical and technical professionals. Hyperbaric chambers are not new technology, and there are, in fact, many national and international safety standards developed to ensure patient safety and appropriate use of such devices. To name only some of the safety standards completely disregarded by the Oxford Center staff on this tragic day were the daily maintenance check was not performed, the pre-dive safety check was not conducted with the now deceased patient, there was no medical doctor or safety supervisor on the premises at the time of the treatment was not performed by a licensed technician, yearly inspections of the hyperbaric chamber, as suggested by the manufacturer, were not conducted, and the essential patient-worn grounding strap was not used. To make money, as a business, the Oxford Center operated these machines and offered unfounded treatments to patients when medical science contradicted these uses of their services. This was an unscrupulous business operating powerful machines beyond their manufacturer's intended term of use on children's bodies over and over again to provide unaccredited and debunked so-called treatments, chiefly because it brought cash into the door. And as I detailed above, they did so in an egregious, willing, or wanton disregard for life-saving safety measures. Because these treatments were so medically unsound, patient insurance policies would not cover the use of these chambers to treat these conditions. The Oxford Center offered to heal or ease. So this business was a pure cash flow for-profit business. The Oxford Center, and of course, its owner as well, owner Tamala Peterson. Thomas Cooper, at just 5 years of age, died in an easily preventable tragedy occurring inside an unsafely operated medical device beyond its intended service years after a treatment not supported by medical science to treat the ailments from which he suffered at a facility that offered these services and managed these devices in defiance of international safety standards in accordance with whatever would provide them the most income or profit. Tamala Peterson, the owner of the Oxford Center, was arrested yesterday near her home and will be arraigned later today on one count of second-degree murder. Gary Markin, a primary manager of the Oxford Center, was arrested yesterday at his home and will be arraigned later today on one count of second-degree murder. Jeffrey Mosteller, the safety manager of the Oxford Center, was arrested yesterday in a traffic stop near his home and will be arraigned later today on one count of second-degree murder. And Alita Moffett, the operator of the hyperbaric chamber on the day of Thomas Cooper's death at the Oxford Center, was arrested yesterday at her home and will be arraigned later today on one count of involuntary manslaughter and one count of intentionally placing false information on a medical record as a medical provider. All defendants are currently housed at the Troy Police Lockup Facility, and each will likely be transferred to the Oakland County Jail following arraignment. Arraignments for each will take place before Magistrate Chiapelli in the 52-4 District Court in Troy. And I'd like to express my sincerest condolences to the Cooper family and my utmost appreciation to the officers of the Troy Police Department. This investigation, I know, was extremely difficult and had a tremendous impact on the Troy and Royal Oak communities. We thank you for your care and your great diligence on this matter. And with that, I will now take any questions you might have.
Thank you so much. If you have a question, please raise your hand and I will call on you. First, we have Dustin with Crane. Dustin, if you can unmute yourself.
Thanks, I appreciate it. We sort of knew that this was going on for a few years. Had your office been aware of the Oxford Center in previous years, or done any investigations? Because we know that they had complaints for other reasons, not to necessarily do with hyperbaric chambers, but had it been raised, and had you been aware of this in the past?
So there had been ongoing investigations, but that dealt more with the issue of fraud than it did the safety of the hyperbaric chamber. So that had not been an issue that we were aware of or had investigated. But there were other issues dealing with, again, issues related to fraud that were where we had ongoing investigations, and of course, previous convictions as well.
Thank you. Next I have Randy. Randy, what outlet are you with?
Channel 7, WXYZ TV. Thank you for the opportunity. A quick question for Attorney General Dana Nessel. These hyperbaric chambers often have fire suppression systems built into them so that if there is any sort of spark, it's immediately extinguished, et cetera, et cetera. Did the hyperbaric chamber in question have a fire suppression system installed and in working order?
So I think I'm going to allow my Criminal Bureau Chief, Danielle Hageman-Clark, to answer that question. Danielle?
We do not believe that it had a fire suppression system on it.
Thank you. Next, we have Kristen Shamus. Kristen?
Hi, it's Kristen Shamus from the Detroit Free Press. I'm wondering if you can tell us whether there are any state, federal, or local oversight of hyperbaric oxygen chambers in Michigan. And is the Attorney General's office reviewing all facilities in the state that use this type of therapy now?
Right. So my understanding is that U.S. FDA regulates both the oxygen used in HBOT and in hyperbaric chambers. And then an organization called the Undersea and Hyperbaric Medical Society offers accreditation for centers who meet or exceed these standards. And then LARA is responsible for overseeing the license of medical professionals that the Oxford Center employs. And the Oxford Center employs one medical doctor on their staff who was not on site that day. And outside of that, Michigan law doesn't require any oversight over the use of hyperbaric chambers. So without having some sort of probable cause to believe that there are crimes being committed involving hyperbaric chambers in other places in the state, we wouldn't have the authority to go in and perform an inspection. And as we noted, like LARA does not have the capability to do that either because they're not licensed within the state. But with that, I mean, there's certainly advice that we can give to individuals or to families who are considering this kind of treatment that I think is important. So for instance, always exercise caution before engaging in any unapproved therapies. For instance, this one, hyperbaric chambers are not an approved therapy for ADHD, but the Oxford Center boasted over 100 diagnoses that HBOT could help with, while the Undersea and Hyperbaric Medical Society only lists 15. Additionally, the Oxford Center offered training and certification program in which one of our defendants, Mr. Mosteller, provided training to other hyperbaric chambers. And I'd strongly encourage any facility that or the ICHT certification to immediately contact the Undersea and Hyperbaric Medical Society for accreditation and additional training. Also, the FDA recommends that you check with your healthcare provider before using an HBOT device to make sure that you're pursuing what's appropriate care. And if an HBOT is recommended, the FDA encourages you to go to a hospital or facility that has been inspected and is properly accredited by the Undersea and Hyperbaric Medical Society, and the Oxford Center simply was not. So the Michigan Department of Licensing and Regulatory Affairs maintains a free public license verification website for those that are interested. So please, if you're interested in this kind of therapy, take the time to verify claimed licenses and certifications of providers, particularly when those positions involve sensitive work or contact with vulnerable populations. And we know that this is a type of therapy that, while it can be helpful for certain types of medical issues, it has to be used properly. This can be very, very dangerous. We're talking about 100% pure oxygen inside one of these chambers, so very flammable, and it has to be utilized correctly. And obviously, we are alleging that in this set of circumstances, it absolutely was not.
Thank you. Next, we have Elizabeth Chuck. Elizabeth, can you say what outlet you're with, please?
Yes, hi, good morning. Elizabeth here from NBC News. I have two quick questions. The first is, I know that the Oxford Center has a second location. Has that second location been shut down, or is that being investigated as well, given the seriousness of these charges? And then second quick question, are you able to tell us any more details about the allegations of falsified medical records that one defendant is facing?
Danielle, I'm going to throw this one to you.
Thank you for the question, Elizabeth. As it relates to the Oxford Center in Brighton, it is under investigation. As it relates to the falsification of medical records, I'm sorry, but in order to be able to preserve the integrity of the investigation as well as this case, that information will come out at our preliminary exam.
Thank you.
And Kristen, you had your hand up for a follow-up. Do you not need that anymore?
Well, the question was just about whether the Troy Center and the Brighton Center were continuing to operate, or whether they've been shut down.
Perfect. Okay, last chance for last questions. Great, seeing no more. Oh, Sarah Wright, what outlet are you with, please?
I am with the Troy Times. I just was wondering, with the state of these machines, as you said, many of them were not being safety checked in a way, would they have any effect on other patients that were using them? Like, would there be any negative impacts as they were used and they were not being maintained as well as they could be?
Yep, that's the basis of our allegation here, is that because they were not maintained properly, that those defendants involved should have known that there, was a chance, a reasonable chance that we would see this kind of outcome. So that really forms the basis of our allegations.
People of the state of Michigan versus Tamala Peterson. Appearances for the record, please.
Thank you. Good afternoon, Your Honor. It's Assistant Attorney General Chris Kessel for the people.
Good afternoon, Your Honor. Joe Gleason on behalf of Ms. Peterson, who is standing in the jury box.
Thank you. Ms. Peterson, state your full name for the record. Thank you. This is an arraignment on the information. How are we proceeding?
Your Honor, I'll acknowledge receipt of the complaint, waive its formal reading, and she will stand mute to the charges.
All right. I'm indicating a waiver of the formal reading of the complaint. A plea of mute will enter to the charged offenses as these are felony offenses. You do have the right to a probable cause conference within 14 days. That is scheduled for March 19th, 2025 at 2:30 before Judge McGinnis. You also have the right to a preliminary examination. That is a hearing in which the prosecutor has to establish by probable cause that a crime was committed and probable cause that you committed it. And that will occur on March 26, 2025 at 9 a.m. You have retained counsel had you been unable to do so and declared indigent or unable to hire an attorney. One would have been appointed for you, as you do have the right to be represented. You also have the right to remain silent. Anything you say orally or in writing can be used against you in court. You understand? All right. So I've entered the plea of
not guilty. The next two court dates have been established. The next issue that needs to be addressed is bond. I will hear first from pretrial services, and then I will speak with you two.
Yes, right.
Brenda Rogers, pretrial services. I did not interview the defendant. She did decline requesting her attorney. Therefore, no references were contacted and limited background information was obtained. Records show she's 58 years old, have an address in Brighton, Michigan. Information in regarding to employment history, use of alcohol or drugs, or any physical or mental health conditions is unknown. The defendant has no prior criminal history on record. She has no outstanding warrants, no pending matters or holds. And given that there is great concerns for the allegations and the presumption of innocence, the defendant does appear to have a stable residence in Brighton. She does appear to be gainfully employed and has no prior criminal history or history of failing to appear. Therefore, it is respectfully recommended that she be released on personal bond. And it is respectfully recommended the following conditions: pretrial services, no possession of a firearm or dangerous weapon, no contact with the co-defendants in this matter, not to return to any Oxford Center, and that she must surrender her passport to the court within 24 hours of release.
Thank you. Counsel?
Thank you, Your Honor. I think obviously it goes without saying the seriousness and quite frankly the tragic nature of these offenses go without saying. What I would ask the court to take into consideration is, first, when we talk about bond, one of the conditions the court is to consider is protection of the public. Now, this isn't your typical murder charge in the sense that there weren't specific acts of violence perpetrated by this defendant, but the people's concern regarding the protection of the public, Judge, is this defendant owns and operates another location where this hyperbaric oxygen treatment is taking place. And the people believe that the continuing operation of that business poses a serious threat to the public. It is only by the grace of whoever that this hasn't already happened before. And so the people would ask this court to impose a bond condition that this defendant not have any conduct supervising, overseeing anything related to the business of hyperbaric oxygen treatment, because it's the people's position that the defendant, in her lack of care, is responsible for what happened to the victim in this case, and allowing her to continue to run those businesses the way she has been for years only puts multiple other potential victims in harm's way. I do agree with pretrial services, Judge. Obviously, because this defendant has no prior record, there is no history of failing to appear. But with this defendant, much more than any other, Judge, the people are concerned that she is a flight risk. What I will tell you, Judge, is that as part of our investigation, the people discovered that recently the defendant applied for and got a visa to China, which is still active at this time. She also recently purchased an amount of uncirculated Iraqi currency, which is very concerning to the people, especially considering the defendant has ties to people out of the state and out of the country. I would also point out, Judge, that days after the explosion, the defendant admitted to wiping her laptop. She lied to investigators to prevent access to video of the explosion in this case. And a previous investigation reveals that this defendant has told other IT tech in her business to wipe devices to essentially destroy evidence involved in other investigations. Judge, I would note that there are witnesses in this case who I and other investigators have personally spoken to that indicate that this defendant has bullied, threatened, harassed, humiliated, and filed lawsuits against people who, for lack of a better phrase, stand in the way of whatever it is she wants to do. Judge, this defendant also has access to a considerable amount of cash. The business that the defendant ran, the treatments that she was providing were not covered by insurance. And what that means, Judge, is all of the clients of this business had to pay in cash, cash or check. And this is a significant amount of money that this defendant has access to. One of the number of LLCs that her name is attached to boasts about raising hundreds of thousands of dollars in pursuit of, I quite frankly am not sure what. But my concern, Judge, is that this defendant has access, as I said, to a considerable sum of money. She is part owner or linked to a number of different corporations. Quite frankly, frankly, Judge, her husband is a forensic accountant, which means they have the means to move and conceal some of this money. And Judge, if I can land this plane, I bring all this up because what is clear in our investigation is that this defendant not only has the means and the ability to leave the state and to leave this country, but she has shown time after time that she has no problem attempting to impede the investigation into her. And quite frankly, Judge, there is no better way to stop an investigation into Tamala Peterson than by her not being here. So that's something that the people would strongly ask this court consider in setting bond conditions in this case. I also agree that if the court is inclined to allow the defendant to be released, again, passport needs to be surrendered immediately. The defendant cannot leave the state without express permission of the court, and obviously any other conditions the court sees fit.
Great. Would you like to say anything as it relates to dangerousness that she poses to the public as a result of the investigation?
Well, Judge, again, I think, again, this is because this is a gross negligence kinds of case. It's not that it's the nature of the business that the defendant continues to run to this day. That is the threat that people are concerned about first and foremost. So the people want this defendant to have no ability to conduct any business or certainly conduct any oversight as it relates to the other Oxford Center location in Brighton. So yes, the people are concerned that she does pose a continuing threat by the nature of the work that she does and the manner in which she does it, I should say.
Right, and in the swear to, I don't know if Detective Trigger, are you going to speak today?
The prosecution.
Okay, in the swear to, I did take some notes from Detective Trigger's swear to, and in that I learned information such as the actual hyperbaric chamber that this young boy died in was past 20,000 cycles a few years ago. Would you like to speak to that?
Judge, I don't want to get too much into the facts of the case. Obviously, I think the appropriate time for a lot of that to come out is at the exam. But yes, our investigation has led us to the conclusion that one of the co-defendants in this case was actively tampering with this particular hyperbaric chamber, and all of the evidence leads us to the conclusion that it was done with the permission and perhaps at the order of this defendant.
And what, if anything, would you like to say as it relates to, I did also take notes regarding lack of safety protocols. Including grounding wires.
Yeah, Judge, I mean, I think it goes, I shouldn't say it goes without saying, but, you know, Judge, the people's position is that this was a very easily preventable situation had the defendant, and again, this defendant as the owner and the boss, for lack of a better word, of these facilities, this could have been prevented so easily if they only would have followed the manufacturer's guidelines, if they would have followed what is considered basic safety precautions. That in and of itself gives the people concern. But again, as the court already noted, not only were they not taking precautions, they were affirmatively making things more dangerous by altering the equipment so as it would look as though it was newer than it was. And in fact, one of the things that the people turned up in their investigation is that in the most recent, evaluation of this particular chamber, the number of cycles was less than had been previously recorded. So obviously, Judge, there's, you know, it's very clear what's going on here. And as I said, the people have spoken to a number of witnesses who can and will testify to that fact.
All right, thank you. Mr. Gleason?
Yeah, I'd like to return to the court rule because there are certain factors there. And I think pretrial services started there, and that's where I think we should stay. I appreciate Mr. Kessel's argument, but I want to focus the court there. First of all, with these proffer about threatening people or wiping this, there's no obstruction of justice charged here. There's no And if that had occurred, we'd see a count for obstruction of justice. We don't have it. So I think that discounts the argument that's being made there. And certainly a no contact provision will certainly protect any issues there. So no obstruction. I'm going to say that's something that we'll see in court. It's not here. With respect to the passport, I have it here for the court. And with respect to applying for a visa to China, it's in the passport. It's dated August of 2024. The purpose of the visa, Ms. Peterson's son got married in China. He's married to a person who immigrated from China, and there were relatives there. That was the purpose of the trip. This was not done recently. It was not done after the incident in question. So that, again, and that's right here. The court can look at it if you want to. It's right on there. With respect to the court rules, I did hear and I agree with pretrial services. She has no prior criminal record. She has no record of flight. She's always appeared. Now, and I want to be clear about this. 2 weeks ago, I told the Detroit Police Department, if charges come, we'll appear voluntarily. No need to go arrest her. We'll present her to the court. We'll present her to the police department. Apparently, that wasn't good enough for the Detroit Police Department, and I respect the detectives. But all they had to do was call me, and we'd be standing here voluntarily. Instead, we're in a box being recorded by the media. And I take issue with that, and I've raised that with the Attorney General's office already. We would have appeared voluntarily, just like I voluntarily brought the passport today. Likewise, if there was flight here, I don't know if the court signed the warrant or another magistrate, but it was signed on March 4th. They waited to the 7th to arrest her. If there was a flight issue here, they would have gotten her the same day. Likewise, Your Honor, with respect to the rule, there's no history of substance abuse, no history of mental health issues. And while the crime of second-degree murder is a serious offense, it carries a number of different mental states. And as the Attorney General stated, there was no violent act here. This isn't the type of second-degree murder that involves a shooting or strangulation or other type of violent act. And likewise, there are 3 different states of mind for second-degree murder: the intent to kill, the intent to do great bodily harm, and knowingly creating a high risk of great bodily harm, knowing that death would result. And I don't think you did the swear to, I wasn't here, but I don't think an allegation is made that she intended to kill anybody or intended to do great bodily harm. And with respect to that third mental state, the court should be aware that both of her parents utilized these hyperbaric chambers regularly. And I think that tends to discount the idea that she was somehow operating these with reckless abandon when putting her own family members in that. That's for another day. I recognize that's a preliminary examination issue. It's been raised today. I'm simply responding to it. Your Honor, with respect to what we have to do to assure the protection of the public, this is not a woman who's going to go out and do further violence. Those hyperbaric chambers, obviously, in Troy, that facility has been closed. The ones in Brighton have not been utilized since this happened. They are going to continue not to be utilized. And I, on her behalf, and I can state to you, if you order it, they will continue not to be used. They're not in use and will not be in use going forward. So the protection of the public, as outlined by the Attorney General, has already been solved, has already been prepared. Now, if the court wishes to have some amount of cash to have her show up, I am not hearing a number from the Attorney General. I am hearing a personal bond from pretrial services. And I recognize what the facts in this case involve. It's a tragic situation. A child has died. There are parents in this courtroom. I'm a parent. I understand that. But in this particular case, this woman does not present a risk of flight. And under the circumstances that we've established at the Brighton facility, there's no risk of danger either. If the court has questions, I'm willing to answer them. But certainly a high bond is not necessary to meet the goals of the court rule here.
Thank you. Next. The purpose of bond is not to punish, it's to ensure the protection of the public and your reappearance in court. This is a very serious case. It involves the death of a young child. It involves the death of a young child in a horrific way. And I'm not going to use the term tragic because I think a lot of what we're looking at was disregard of safety protocols that created the risk of this happening. And that's exactly why we're here today. Had a grounding line been employed, had the tally for how many cycles of this chamber not been altered, it read less than it did in 2022, this child would be alive today. So in my mind, that is an individual that runs a business entity with the goal of making money and throwing safety and caution to the wind. I have heard that she had wiped her laptop, that I also heard from the detective when they were trying to obtain a cell phone. I don't know if it was in a parking lot or where it was. She actually ran from the investigators. I also heard from the detective that there were statements. I really am hastened to get too deep into this because if there's anyone in the courtroom, I don't want to upset them. But I will state that I believe there was inappropriate use of still photographs taken from the CCTV of this incident. And comments made regarding that. There was also information regarding a previous Attorney General investigation that your office handled that involved an individual lying essentially about accreditation to work in the facility.
Judge, if I may, that wasn't raised here. I haven't had a chance to respond.
Well, he can raise it if you'd like to state it.
Well, Judge, I think, and actually the prior investigation that I was referring to isn't even that investigation. It's another investigation involving healthcare fraud allegations. So that is the people's overarching concern. Is it is very clear that this defendant, and thank you for reminding me, Judge, and Detective Trigger told me that this defendant literally, when it was made clear her phone was to be examined, she grabbed it and ran. So the people's overarching concern is that this defendant has a well-documented history of attempting to impede law enforcement, and her lack of appearance would be, you know, the cherry on the sundae, if you will, of impeding the investigation to the best of her nature.
Well, in order to maintain the integrity of the judicial proceeding, I have to ensure that she's not going to continue in behavior that's alleged, that she will appear in court as directed. But what I can't get beyond is an individual whom the allegation suggests would put a person at risk of harm by simply not adhering to standard safety protocols and tampering with the reading of this particular chamber. The very nature of the hyperbaric chamber is higher levels of oxygen, highly combustible, risky, dangerous. Should really be handled with the utmost care and concern and respect. The history of Ms. Peterson troubles me as it relates to impeding investigations. This case is of great concern for public safety. If this is how this operation is being run, I'm so relieved that this hasn't happened before. I'm horrified for the family, and I'm not going to call it tragic because, again, I don't think that's the correct term. I think this was foreseeable. Tragedy implies something that's not. She does have access. I will take the passport. We will take that prior to any posting of bond. That will have to be submitted to the police department for safekeeping. She does have essentially a cash business. She has the ability to, she has the means to leave. She has the ability to circumvent this investigation based on her history, the best predictor of future behaviors past. But what I'm going to do at this point in time is set her bond in the amount of $2 million with the following conditions. She'll be under the supervision of pretrial services. She will have no contact with Alita Moffett, Gary Markin, or Jeffrey Mosteller. She will not return to the Oxford Center, neither virtually or in person, the Troy location or the Brighton location. She shall submit her passport prior to release. She will be affixed with a GPS tether, steel cuff prior to release with home confinement and restricted leave. No contact with any current or past employee, officer, service provider, or maintenance entity which has had any contact with the hyperbaric chamber in question. Do not leave the state of Michigan without permission of the court. Personally appear for all court proceedings. No new criminal offenses or activity. And immediately notify the court in writing of any address, phone number, or email changes. No corporation or business entity of which defendant is, was an owner, officer, or director of care, past or present, shall operate a hyperbaric chamber in the state of Michigan. The Oxford Centers shall cease all operations related to hyperbaric chambers.
Your Honor, if I may.
One moment.
Yes, ma'am.
Furthermore, she is not to possess any firearms or weapons, and they shall be turned into the arresting agency and provide proof to the court at 524 bond compliance at OCOG.com within 24 hours. Mr. Gleason.
Your Honor, the court considered a 10% revision. That's a very substantial bond.
The bond that I set is actually lower than I anticipated.
You're the judge.
Thank you.
Yes, ma'am.
I'm going to take her out. Okay. Line 25-000875FY. People of the state of Michigan versus Gary Markin. Here's the record. We'll just wait for that later. Thank you.
Thank you, and good afternoon again, Your Honor. Assistant Attorney General Chris Kessel for the people.
Thank you.
And good afternoon, Your Honor. It's good to see you. Raymond Kassar on behalf of Gary Markham.
All right, how are we proceeding with the arraignment?
Kind of at this time, my client would waive the formal reading. My client would also stand mute to the charges.
All right, thank you. Indicating a waiver of the formal reading, a plea of mute to the charges will enter on your behalf, sir. You do have the right to be represented by an attorney. You sought out and hired your attorney of record and been unable to do so, and upon request, you would have been considered for the appointment of an attorney. Furthermore, as you are charged with felony offenses, you do have the right to a probable cause conference within 14 days. You also have the right to preliminary examination within 21 days. That is a hearing in which the prosecutor bears the burden of proof to establish by probable cause that a crime was committed and probable cause that you committed it. The examination date is March 19th, 2025 at 2:30.
Exam, Your Honor, or probable cause?
Excuse me, probable cause.
Yes, Your Honor.
Thank you. And the examination date is March 26th, 2025. And so I should also indicate to you that you do have the right to remain silent. Anything you say orally and writing can be used against you in court. So I have indicated the waiver of the plea, enter pleas of mute to the charges. Next issue is bond. Ms. Rogers?
Your Honor, Brenda Rogers, pretrial services. I did interview the defendant. I was not able to verify his information. He did provide his wife, but did not have a phone number for her. He reports he's 65 years old, born in Michigan. He's been married for 41 years. He has 3 adult children, currently living with his wife in Spring Arbor. He reports living in Jackson County for the past 6 years. Working full-time at the Oxford Center as a director of facilities at the Brighton location. He states he's been there for 16 years. Regards to alcohol, marijuana, or any drug use, he denies all use. Reports he's in good physical and mental health. The defendant has no prior criminal history on record. However, there is great concerns regarding the allegations and the possibility of penalties if convicted. The defendant does have gainful employment of 16 years. He has stable residence. He has no prior criminal history, no outstanding warrants, no pending matters, and no history of failing to appear. Therefore, release on personal recognizance is being recommended. Pretrial services does have concerns for the public safety related to the continued operations of the Oxford Center, and for those reasons, the following conditions are being recommended: not to return to the Oxford Center virtually or in person, have no contact with the co-defendants in this matter, must surrender passport to the court within 24 hours of release, be supervised by pretrial services supervision, no possession of a firearm or dangerous weapon, and no contact with the family of the listed victim.
Mr. Gleason, and adding that as a condition of bond to your client as well, no contact with the family of the listed victim.
Yes, Your Honor.
All right, thank you. Counsel.
Thank you, Judge. Again, I think we don't need to go over some of the more, some of the specifics regarding the seriousness of the case. I will say that people outside of the general concern about flight in a case this serious, we don't share the same concern about flight with respect to this defendant as we did with Ms. Peterson, for the reasons that we stated on the court, to the court. But again, we are greatly concerned, as we talk about with respect to Ms. Peterson, that this defendant was personally involved in altering these machines in a way that made them seem like they were safer than they were, made them seem that way to the manufacturer, made them seem that way to the patients. And again, in this case, it was this one specific machine that multiple witnesses have identified that this defendant was working on, rolling back those numbers. In essence, I hesitate to use this phrase, Judge, but I don't know one that's more applicable. He was literally making this a ticking time bomb. That's what his actions were doing. So the people are very concerned about that as it relates to bond. Otherwise, I think the rest of the factors have been addressed with respect to Ms. Peterson, so I don't have anything additional. Actually, other than to say, and I suspect the court is leaning this way, that this defendant, as part of his bond condition, should have nothing to do with the Oxford Center or any other hyperbaric oxygen treatment facilities or treatments or anything of that nature.
Thank you. Counsel?
Thank you, Your Honor. Your Honor, first and foremost, we do recognize the seriousness of the charges. At Attorney General Nessel's press conference a couple hours ago, she indicated these are merely charges and the accused is presumed innocent. And I want to keep that in the court's mind, that he's presumed innocent. I will tell you that Mr. Markin has not been to the Oxford Troy facility in over 3 years. I don't know where the information is coming from that he is rolling back any of these things, but I can tell you that we're confident he hasn't been to that facility because he worked at the Brighton facility. However, Your Honor, with respect to protection of the public, there's no concern that he is going to do anything at this point in time to endanger the public or do anything that would cause the court concern to the public. He didn't operate these machines, Your Honor. He was a facilities manager, and I'm sure that's going to come out at the time of the preliminary exam. Your Honor, with respect to previous criminal history, none. 65 years old, married 41 years. His entire family is in this courtroom. They support him. He was on salary. He was not making a huge amount of money at this corporation. He does not have ties to any other countries. He doesn't have any major assets to give to the court. But I will tell you the most important thing that the court should know and take into consideration is that we were offered an opportunity to sit down with the authorities, and we agreed to sit down with the authorities with the understanding that we could bring this man in when the charges came due. He sat down with the authorities, explained his role, explained his involvement in this, gave his passcode to his phone and his phone. And we were under the impression that we would be able to bring him in today, walking him in as opposed to him in handcuffs. Your Honor, I think that goes a long way towards your recommendation for bond. If this guy's willing to sit down with the authorities and give his side of the story freely and voluntarily, then you have to take that into consideration. And I know Sergeant Flood's in the courtroom, and he would be nodding his head right now and saying, yes, that's correct. He did sit down. He did agree. Others may or may not have done that, but we did, Your Honor. Your Honor, he's cooperated again with the police. He is battling skin cancer. He is scheduled for surgery April 1st. I think the court should take that into consideration. I think that makes sense. He's led a full life of law abiding. Now, I don't know what proofs they're going to be able to show with respect to rolling back these, whatever these tickers or these things, but I think that they've got a heavy burden to show that he knowingly did this and that he knowingly knew there was a risk of harm, of death in a case like this. Your Honor, with respect to probability of appearance, he lives here in Michigan. He's lived in Michigan all his life. There is no reason for him to leave. Again, I bring up the fact that why would he sit down with the authorities and discuss the case with them when they were in need of information that he provided? Your Honor, I think the recommendation for a high bond wouldn't, if there's a recommendation for a high bond, I would disagree with it. I think pretrial service is correct. A personal bond makes sense. You can achieve all these goals by giving him a personal bond with conditions like a GPS tether. If you want to keep track of them, that's fine. A GPS tether makes sense. There was no reason that he would flee. There's no reason that he would leave the jurisdiction. I'm asking the court to allow us to really represent him instead of representing him behind bars. I'm assuming there's going to be volumes of discovery in this case, Judge. And as you know, dealing with the jail, going back there with computers and videos that we're going to have to look at is going to make this case 10 times harder. I'm asking you to consider a personal bond. I'm asking you to consider, if you are not inclined to do that, some sort of a 10% bond that is reasonable in this case. And again, I have to make a big deal about the fact that when he was asked by the police, will you sit down and cooperate with us? He said, yes, and he did. So, Your Honor, I would take that. I would ask the court to take that into consideration, take into consideration the health, the issues that we've got to deal with, that he's got surgery scheduled for April 1st, and impose a reasonable bond with conditions as you see fit, Your Honor. Thank you.
Mr. Martin, have you stated your opinion for the record as previously stated? Thank you. Sergeant, would you like to respond to anything that counsel brought up?
Oh, Sergeant Flood is.
Oh, Sergeant Flood. Yes, would you like to reply to any of that?
What counsel says.
And okay, thank you. All right, so again, purpose of the bond is twofold. It's to ensure your appearance in court as well as protection of the public. This case, by the very nature of the allegations, a hyperbaric chamber with high saturations of oxygen is essentially a ticking time bomb. If that unit is tampered with, it becomes Russian roulette for whoever gets into that chamber. This was a 5-year-old boy. His life is gone. His mother essentially did what all parents would say: I would walk through fire for you. My understanding is she put her arms into fire to try to save her son. I cannot risk that happening to any other human being on the face of the planet Earth. That is such a torturous, horrific, heinous image. I have to ensure that you never have the ability to come near, or I'm not saying never, I'm saying while you're on my bond, not come near any sort of facility that participates in the treatment using hyperbaric chambers. I also, going back to my understanding of his involvement with Ms. Peterson, is that they basically were hand in glove. They shared an office at the Brighton location. If he were to be the person that we're doing her bidding, turning these things back, obviously that's a very dangerous person in my purview. The charges are substantial, they're severe. We're dealing with a murder 2 charge, in addition to the involuntary. I need to ensure his presence in court. I need to ensure the protection of the public, and I am setting bond in that regard to do so. I am setting the bond at $250,000. Cash surety with no 10%, pretrial services supervision. No possessing any firearms or weapons, carried to the arresting agency and provide proof to the court at 224 bond compliance bill.com within 24 hours. No contact with Tamala Peterson, Jeffrey Mosteller, or Alita Moffett. Do not return to the Oxford centers in Brighton or Troy, virtually or in person. There will be a GPS tether prior to release, passport turned in prior to release to the police department, with home confinement, restricted leave, attorney, medical in court. In addition to verified employment, I don't know what that will entail, shall not seek employment with any entity that provides hyperbaric chamber treatments. Do not leave the state of Michigan without permission of the court. Personally appear for all court proceedings. No new criminal offenses or activity. Immediately notify the court in writing of any address, phone number, or email changes. No contact with any current or past employee, director, officer, service provider, or maintenance entity which has had contact with the hyperbaric chambers at the Oxford Center. Any questions? All right, you can see this, sir.
Thank you, Your Honor.
Line 25-000878FY, people of the state of Michigan versus Jeffrey Allen Mosteller. Appearances for the record, please.
Thank you. Good afternoon again, Your Honor. Assistant Attorney General Chris Kessel for the people.
Michael Dick on behalf of Mr. Mosteller.
Mr. Mosteller, would you state your full name for the record?
Jeffrey Allen Mosteller.
Thank you. How are we proceeding with your arraignment?
At this time, my client would like to waive formal reading and stand mute.
Right, Mr. Mosteller, I'm indicating a waiver of the formal reading of the charges. Please, if not guilty, vote enter on your behalf. You do have the right to a probable cause conference within 14 days. Yours is scheduled for March 19, 2025 at 2:30 p.m. before Judge McGinnis. For the PCC, you also have the right to a preliminary examination within 21 days at a hearing with the prosecutor as to establish by probable cause that a crime was committed and probable cause that you committed it. And that is set for March 26, 2025 at 9 a.m. You also have the right to remain silent. Anything you say orally or in writing can be used against you. You also have the right to be represented by an attorney. Is he requesting appointment of counsel?
I believe he indicated that he believes he might have retained, but I'm not certain at this point. We did fill out a request for attorney form, Your Honor.
All right, sir, so you've got a few options. You can hire your own attorney, which may take some time. I don't know what your financial situation is. Or you can petition the court for the appointment of an attorney, and that would be appointed by the MIDC, and they would determine whether or not you're eligible. Or, of course, third and bad option is to represent yourself.
Well, then I'll go for the court one.
Okay, so at this point in time, I will review your petition for the appointed counsel. If you are able to secure retained counsel, we ask that you do contact the court so that we can call off an appointed attorney. All right, sir?
Yes, ma'am.
Your Honor, not to interrupt your review, but this does include employment at the Oxford Brighton location. So any income, if that were going to be.
Okay. All right, so based on the information that's been provided, taking out any income from the Oxford Center, if you find that you qualify for the appointment of an attorney, so one will be, I will send this up to the appointing authority to have an attorney to represent you. Does your phone number end 6719? All right, thank you. The next issue is bond, purpose of which is to ensure your presence in court as well as protection of the public. Ms. Rogers.
Commissioner Brenda Rogers, pretrial services. I did interview the defendant. No report was completed by investigator Heather Golan. She was able to verify the defendant's personal information with his girlfriend Pamela Vera. The defendant is 64 years old, born in Georgia. He is divorced since 2016. He has no children. Reports living in Clinton Township with his life partner Pamela since 2019. He does report full-time employment at the Oxford Center in Brighton, Michigan as a safety director and educator. He states he's been there since July of 2019. He does report he's obtained an associate's degree in underwater technology. He denies any use of alcohol, marijuana, or illegal drugs. No history of substance abuse was reported. He states he's in good physical and mental health. He reports that he was arrested on this offense during a traffic stop in Clinton Township on yesterday's date. Defendant has no prior criminal history on record, no outstanding warrants or holds or history of failing to appear, no pending matters. While there is great concern regarding the allegations and possible penalties if convicted, there is no reason to suggest that he's a threat to the community at large or a flight risk, given his stable residence and employment. Also, given the concerns for public safety, pretrial services have concerns regarding the continued operations at the Oxford Center. For that reason, we are recommending the defendant not return to the Oxford Center either virtually or in person. They be released on personal recognizance, supervised by pretrial services supervision, no possession of a firearm or dangerous weapon, no contact with the listed co-defendants or the family of the listed victim, not to return to any Oxford Center, must surrender his passport to the court within 24 hours of release.
Oh, thank you. Your Honor, again, as with respect to Mr. Mark and this defendant, we don't need to, sorry, I'm getting echo here. We don't need to repeat, the seriousness of the offense. Again, there is not any specific concern with this defendant as it relates to flight outside of the serious nature, potential penalties in this case. This defendant was the, for lack of a better phrase, safety officer at the Oxford Center, which is something, considering the way that this facility was being operated. That the court is aware, multiple safeguards were being disregarded knowingly. The investigation showed that this defendant was conducting his own experiments to try and prove the safety as it relates to this particular chamber. Judge, obviously these were his own experiments, none of which were actually recognized by any sort of scientific body. They were not peer reviewed. The people's position is they were just designed to hide the actual safeguards that were being disregarded. That these experiments were meant to show the under employees that what they were doing was safe, because look at these experiments that he conducted. So that, again, is to Mr. Martin, that is the people's concern, that this defendant had no contact with and had nothing to do with any sort of hyperbaric oxygen treatment, or really any other treatment involving oxygen as well. I would ask the court to incorporate those into its bond conditions.
All right, thank you.
Your Honor, we are asking for a reasonable bond. My client has no prior criminal charges or convictions, no prior failure to appear. I have no doubt that if he were made aware of the charges, he would have appeared in court today on his own volition, rather than being pulled over in a traffic stop in which there were no new pending charges or tickets issued. I believe he was just stopped like many of the other defendants here in order to be picked up at the same time. A lot of the safety concerns, I believe, can be adequately addressed through the terms of his bond. Though through any specific ones that were just mentioned, I don't feel confident directly speaking to those, as I am not going to be his counsel moving forward. So I don't want to speak to any specific allegations. But other than his clean record, we would ask for a reasonable bond in this place, Your Honor.
All right, once again, purpose of bond, twofold: ensure your presence in court, protection of the public. As a safety director, the allegations suggest that you were at the fail stop, taking direction reportedly from someone above you as how to run this facility. And what the prosecutors just indicated to me is frightening, that safeguards were not utilized, experiments were done to show employees, lead them down a wrong path, that things were safe, when obviously they were not. Not tragically, not going to use that word. This could have been prevented if proper protocols were followed. I can't get over that form of judgment was utilized. And if that's the form of judgment that you're utilizing in your life, I have some concerns about you and your ability to participate in the criminal process going forward. I don't know what other judgment calls you would make in terms of would you plead, would you not come back to court. This case is too serious. It must be brought before the court system. For those reasons, and incorporating by reference other statements previously made on the record, I am setting your bond at $250,000, cash surety, no 10%, pretrial services supervision, no possessing any firearms, attorneys to the arresting agency and provide proof to the court at 52-4 bond compliance, com within 24 hours. No contact with Tamala Peterson, Gary Markin, Alita Moffett. No contact with the family of the listed victim. Do not return to the Oxford centers, either Troy or Brighton, virtually or in person. GPS tether prior to release, steel cuff, restricted leave, home confinement, attorney, medical, and court in verified employment. You shall not seek employment with any entity that provides hyperbaric chamber treatments or the use of oxygen. Passport to be turned in prior to release to the police department. Do not leave the state of Michigan without permission of the court. Personally appear for all court proceedings. No new criminal offenses or activity, and immediately notify the court in writing of any address, phone number, and/or email changes. And I haven't confirmed any of these defendants' addresses on the record for a purpose, and that's because everything's being recorded and I'm not trying to turn everyone's address to the public. But we will need to confirm that prior to everyone departing today. No contact with any current or past employee, director, officer, or service provider or maintenance entity which has had any contact with hyperbaric chambers at the Oxford Center. Any questions, sir, regarding your bond or any conditions? Have a seat, sir.
Thank you, Your Honor.
Or actually, you can go with the officer. Calling case number 25-000877 SY, people of the state of Michigan versus Alita Harvard Moffett.
Thank you one more time, Your Honor. Assistant Attorney General Chris Kessel for the people.
Thank you.
Good afternoon, Ellen Michaels on behalf of Alita Moffett. My P number is 67943.
Thank you. Would you please state your full name for the record? And counsel, just to inform you, I was handed a stack of what appeared to be letters in support. I did not read them because I did not believe they were submitted to you at that time.
They were, Judge. I spoke with counsel yesterday. She let me know they were coming. I did have a chance to have a look.
All right, thank you. So I can review those or you can summarize those, whichever is your preference. But in the first instance, we are here for an arraignment. So how are we proceeding?
Well, for purposes of the arraignment, we'll waive formal reading and I'll stand my client mute.
We're indicating a waiver of the formal reading, a plea of mute enters on your behalf to the charges.
Would Your Honor be willing to step away from the bench for 5-10 minutes to review those letters? We would prefer that.
My concern was just that. I wanted to make sure that they were provided. I see that.
Yes.
I didn't want to assume that. So
I understand. I should have let the clerk know. I did actually.
Okay.
Either way, I sent the letters to the Attorney General last night with the follow-up this morning on some additional letters, and all of those were hard copies given to the staff of the court.
Okay, so let's get through to the arraignment stage, to the bond stage, and then I'll take a brief break, okay?
Thank you.
All right, so this is a 2-count complaint. How are we proceeding with the actual arraignment?
We waive formal reading and stand my client mute.
All right, so I've indicated a waiver of the formal reading, a plea of mute to the charges is entered on your client's behalf. And you do have the right to have a probable cause conference within 14 days. That is a hearing in which the prosecutor, not that one, probable cause conference within 14 days. That's going to be scheduled for March 19th, 2025, Judge McGinnis at 2:30. You also have the right to a preliminary examination within 21 days. That is a hearing in which the prosecutor has to establish by probable cause that a crime was committed and probable cause that you committed it. So that will be March 26th, 2025 at 9 a.m. You do also have the right to remain silent. Anything you say orally or in writing can be used against you in court. You hired an attorney, so you retain counsel. Had you been unable to do so and upon request, you would have been considered for appointed counsel and had appointed counsel if you were eligible. Any questions so far, ma'am? All right. So I am going to take the letters into chambers and I'll take about a 15-minute break and then we'll reconvene and address them.
Thank you so much.
Thank you, Judge. Or Your Honor.
Filed our lawsuit as of yet. Right now, we're waiting on the investigation to continue. And as you know, that charges have been brought against 4 individuals associated with the Oxford Center. So that'll create a small delay, not a long delay, in us receiving all the reports. We've also filed a motion for injunctive relief so that we can enter into the building and do our inspection and have our experts evaluate hopefully the electronically stored data, which would be emails, memos, anything on servers. We're also going to be inspecting the chamber to see what exactly happened, were there any malfunctions, and what type of errors led to this, because there's really no defense from our perspective to what had happened. So we just need to get into the facility to do our root cause analysis of what happened.
There we go. How's the family right now?
Oh, they're horrible. When something like this happens and you lose a child, you know, the amount of grief that you're hit with and how hard it is to work through. But in these weeks, now that we are past this, it's starting to be, this is the reality, and the emptiness that you feel when that loved one is gone can never be filled. And in our system, you know, people look to the courts for justice. It's a symbol and it means something, but none of it will ever bring young Thomas back. We don't have a system of perfect justice. We don't have a system where if the prosecutor wins the case or when we go into trial and we win the case, we don't get perfect justice. We don't get to hand the mother and father their child back. We don't get that. And we do have the best system in the entire world, but it's not perfect.
Do you know if this place had everything that they needed to operate, you know, legitimately? I know there's probably not too many licensing for a hyperbaric chamber place.
Well, there's no state oversight or regulation in the state of Michigan. Some states do, and we are calling and asking for that to happen. We do believe that when things go wrong with these pieces of equipment, and the Oxford Center will tell you the same thing, the danger is so high, which is why we need oversight and why we need better training and regulations on this. And based on the charges that were filed, 3 of them were charged with second-degree murder. All of them were charged with manslaughter, and 1 was charged with falsifying medical records. And in a situation when you're charged with those serious crimes, these felonies, the prosecution has to believe that the evidence that they have is incredibly compelling, it's incredibly strong, and you know, this isn't, say, for example, an auto crash where an investigation can be done in a matter of just a couple days. There are some technical aspects to this, and in relatively short order, the prosecution has charged not 1, not 2, not 3, but 4 individuals in connection with this. And what's really important to understand with these charges is there's an element of causation, meaning that they could be operating and having all kinds of problems with the way they train, the way they do things. But if it doesn't have a role in the causation of what happened, you can't charge them. So the prosecution must believe that not only do the failures that they have uncovered through their investigation were significant, but they played a significant role, a causation role, that it actually was a cause in what happened to young Thomas.
There we go. And just like you said, obviously this is not going to bring him back, but this is hoping to help relieve at least some of that pain that the family is kind of.
Well, and that's a great point, because with our access to courts and our access to justice, when you look at what the remedy is, what can happen as a result, and as I said before, it's not perfect justice. You don't get your son back. You don't go in and all of the damage to your body, it doesn't just get healed. But that doesn't mean we do nothing as a society, because when people stand up, whether it's the prosecutor and the government seeking charges, or whether they come to our office, Feiger Law, for help, we get justice as well. It doesn't mean we sit back and do nothing. It means we stand up, because the efforts that we can take individually can make the greater safer.
Well, right now, court documents are revealing some disturbing details into the death of a 5-year-old boy that died inside of a hyperbaric chamber. Now, the swear-to document that was revealed ahead of this week's arraignment breaks down what was going on inside of Oxford Center in Troy. Victor Williams has been following this story. So, Victor, there's allegations of wrongdoings and trying to cover them up.
That's right, Damon. And while the owner and operator of this facility is on a $2.5 million bond, we've been going through these documents that show why that number is so high to begin with.
There are lockstep procedures that are in place to prevent this sort of thing.
Aside from allowing a child to wear pajamas that allegedly caused static electricity sparking the fatal explosion, and then taking a photo of the child's body on fire, sending it to a person via text message, it's also said that workers at the Oxford Center didn't even give 5-year-old Thomas Cooper the proper grounding strap to ensure his safety while undergoing treatment.
You have to be grounded. You give them a little electrostatic gel, you put the ground on, you test that ground, you verify that you are grounded, and then you ground that to the chamber. So it's one of those things that you actually have to make sure is in place.
Dr. Joseph Deturi is a hyperbaric chamber expert who says that certain procedures have to be followed to a T to make sure nothing goes wrong.
My biggest thing here is I don't want anybody to get the impression that every hyperbaric facility is like this.
Documents also show the Oxford Center Troy location prioritized dollars over patients, bringing almost anyone in the door. In an exchange of text messages between Anderson and someone else, the question of if the hyperbaric chamber would cure erectile dysfunction is raised. Anderson's response was, quote, "Whatever gets bodies in those chambers."
I'm horrified. I'm horrified by a person that would do this to another human being, like, oh, they didn't do anything.
Now, Peterson remains behind bars on that $2 million bond. She's with Jeffrey Mosteller, who also is behind bars, but they're going to be returning to court in just a few weeks alongside 2 other employees that bonded out. Live in Troy, Victor Williams, Local 4.
All right, Victor, thank you.